Well, good morning to you that are just waking up, and good evening to the rest of you. I am excited. I just woke up. I know it's late. It's 9:58. I had a hell of a good day yesterday, very productive, but it was exhausting. But it ended on such an amazing note, and that was that Zellner filed a petition. I'm trying to think what it's called. Let me just get it on the screen, you guys. Oh, it's way at the top. Of review, I believe. I don't want to mess with my screen. I think it's a petition of review. But I'm so excited. We got cut off last night because I got a massive storm for like 2 days ago. We got one, took down over 50 trees. Like people lost their car. There was crushed barns. We did lose one individual, a linesman, that got struck by lightning. So I just want to say before we get rolling, because there's nobody here with me on the screen, I just want to take a minute for all the linesmen out there that dedicate their job to making their buck by ensuring that we all have electricity. They risk their lives in storms and bad weather to go up on high places and mess with electricity. So that takes a special tenacity in life, and you almost have to have just a sense of understanding between you and the universe that you're going to be protected to get up there. So God bless you all of you line workers. Now, we've had another storm. Good morning, Kevin. How are you? We've had another storm, but it was not nothing compared to the last one. So, but all in all, for the amount of community people, I live in an incredible town. Like, everybody doesn't even talk about it. They just start getting busy as soon as the storm's over, and they cluster together, and I don't know, it all gets cleaned up. So, hey, David, how do I say that? Ceteris? I hope I did you justice. Hello to you. We're about to get going here. I've got us on page 14. I did do part 1 last night. I don't like to make these videos over 30 minutes really anyway, because you guys, we got so much stuff to do every day. So this may take another video after this to get it done. Okay, so it's 5 p.m. where Kevin is, and just about to set off for work. Well, this can be your podcast if you like, Kevin. Oh, you guys, I got some awesome news. So I found out that after I schedule a live, we can actually have a premiere attached. We do the blackouts every week. Now, this week is being replaced with Zellner's delightful review. Oh, 4 p.m. Okay. And so, with the fact that we're already doing a blackout, I think before the blackout releases, which we'll put that as the premiere upcoming, we'll have a little maybe 15-minute, 20-minute live just to kind of kick the blackout off, okay? So it should be a lot of fun. Everybody wants to see my face. I'm going to tell you something. If I feel up to it, I'll show my face on the lives, and if I don't, I won't. I do what I'm comfortable with. Like today, I'm not even dressed. I'm still in my t-shirt and, comfortable with you guys, because that's what the fun of YouTube is I get to be me completely all the time. Now, if I'm looking halfway decent, I'll share. Or if I'm too excited to care what I look like on the Evers. So Governor Evers came to my hometown, a surprise shock to me, and I got to talk to him about Brendan Dassey. Now, I do have that recording. I uploaded it accidentally to the 1111 Tarot channel. I could delete it off there, but I'm scared to because it's so hard to get to transfer. I will try to transfer it over to this channel, but if I don't, what I'm thinking of doing is putting a link to the Governor Evers full, what do you call it, where I went live and on site, where I was a reporter, a dream of mine. It was incredible. Like, you guys, I think I'm meant to be like this. Because, okay, I'm just going to get real with you guys before we start this. I think that all of us that are doing this armchair sleuthing are technically the real journalists. Because we're digging into facts. We're not being force-fed through some teleprompter what Calumet or Manitowoc County is feeding to us, where our job is dependent on reading exactly that script. We are freelance researchers. We are freelance journalists, is what I'm going to call us. Truthers. All right. Who's ready for this? I think we have enough in the house. Let's do a little check. We've got 6 people. That's good enough for me. Even if I just have one of you, I am ready to do this. So let's get rolling. Hey, Jill. Jill Messman. I don't remember seeing your name before. I'm so glad to hear from you. Let me get a little drink. We're going to start this up. Get this good energy ball rolling this morning. I'm warming my hands if you hear weird sound. Ooh. It's chilly. I'm thinking I'm going to grab my robe, you guys. Ouch. Hit the knee. That was fun. Now, how could my robe be gone? Maybe a blanket? Oh, I'm sitting on my robe. How silly. It's so real life here, you guys. I kid you not. I am in the ugly pink fuzzy pink robe, you know, the one that I've had for like 5 years. It's clean and neat and there's no stains, but you could tell it's just old. But it's so wonderful. Hey, Zelma. Good. We got Zelma Lopez in the house. All right, Kevin, David, Jill, Zelma, and everybody else. This is for you guys. We're starting on page 14. We left off yesterday during the storm. This is part 2. And it says, now forgive me, I just kind of woke up. My voice is just kind of waking up as well. So it might be a little rough, but let's do this. Whether suppressing and withholding a CD for 12 years containing a forensic police report of allegedly impeaching and or exculpatory material requires an evidentiary hearing to determine if a Brady violation has occurred. In light of this court's holding in Waysky, I think it's Wayersky, and United States Supreme Court jurisprudence, yes. This court should address, number 1, whether defense counsel's failure to replicate a forensic evaluation relieves the state of its Brady obligation to disclose exculpatory and or impeaching forensic findings. Number 2, whether the state's conduct constitutes suppression. And number 3, whether the Court of Appeals erred in failing to consider the cumulative effect of errors in violation of Kyles versus Whitley. This court should determine whether the denial of an evidentiary hearing was due to the lower court's misapplication of the law governing Brady. Ooh. Oh, I shouldn't clap. That's loud on the mic. I'm sorry. It's hard, you guys. I'm so excited. This is beautiful writing. And people say, why do I love Zellner? Well, just listen. The court determines whether the motion on its face alleges sufficient material facts that, if true, would entitle the defendant to relief. This is a question of law that is reviewed de novo, State versus Bentley. If the motion raises sufficient facts, the circuit court must hold an evidentiary hearing. If the movement presents only conclusory allegations, or if the record conclusively demonstrates that a defendant is not entitled to relief, the circuit court has the discretion to grant or deny a hearing. Part A. The Veely CD discovered 12 years after Mr. Avery's trial. Mr. Avery alleged the following facts. On April 21st, 2006, an agent, S.A. Factbender, and an investigator seized a computer from the Dassey residence. The state's forensic expert, Detective Veely, conducted the forensic examination of the computer. The state misrepresented to the defense that the examination was of Brendan Dassey's hard drive. Right? Hey, Ronald Cass from Missouri Ozarks. Good to hear ya. This state, yes, this state definitely did okay, she's nailing this. On May 10, 2006, Valey, I don't know if it's Valey or Viley, but Valey completed a final investigative report based on his analysis of computer hardware and crime scene facts, which included 2,632 unique word searches and 14,099 refined pornographic images, 1,625 of which had been deleted. Valey's report was 2,449 pages and was downloaded to a CD, the Valey CD. The CD was kept in the exclusive possession of Fassbender, aka Factbender. On April 17, 2018, current post-conviction counsel received the Valey CD for the first time from the state. The Valey CD reveals that the state's forensic analysis is based on the use of the computer by the state's primary witness and trial counsel potential Denny suspect Bobby Dassey, also known as Bobby, and not Brendan Dassey. The Valey CD creates a timeline impeaching Bobby's testimony that he was sleeping immediately before the time of Halbach's murder. It is an evident that the Court of Appeals was either unfamiliar with the record or disregarded it entirely. It stated that, quote, it was skeptical that the Valey report impeaches Bobby's testimony about sleeping and accused current post-conviction counsel of misstating that Bobby was home alone on October 31st, during the time the computer searches were conducted. However, the Court of Appeals did not consider the fact that Bobby himself testified that he was the only person home from 6:30 a.m. until 2:30 p.m. that day, the relevant time period of the searches. Hey, David Case from Missouri, too. There you go, homies. The Valey CD contains thousands of images of violent pornography and word searches revealing a propensity for sexual violence by Bobby, because there is no possible way that current or prior counsel could have guessed the specific search terms and the results which Valey obtained. Mr. Avery was deprived of material information he could have used to establish a direct link between the specific evidentiary terms related to the Halbach murder. Buting attested that trial counsel would have included such information in their Denny motion if it had been timely disclosed. This evidence could have established motive for trial counsel's Denny motion, which the trial court found was the missing element. This court should address whether there is a burden on the defense to replicate state forensic findings, which have been surreptitiously withheld from them. I've never heard that word, but I'm going to be looking it up. Brady placed an affirmative duty on the prosecution to disclose exculpatory material evidence to the defense. In United States versus Augers, the Supreme Court expanded on its holding in Brady, reiterating that prosecutors have an affirmative duty to disclose exculpatory evidence. This court rejected previous interpretations of Brady, finding, quote, the exclusive possession and control, reasonable diligence, and intolerable burden limits distort the original Brady analysis and the purpose behind the prosecutorial obligations enunciated in Brady. And that's in Weyerski. This court specifically rejected the imposition of a reasonable diligence standard on trial defense counsel, stating, the court has never analyzed a Brady claim through the lens of reasonable diligence, and we decline to adopt that requirement now due to its lack lack of grounding in Brady or other Supreme Court precedent. I can't even read that. I got to reread that. Did you hear that? Did you guys pick up on that? Oh, hey, Polygraph. Love you. Nicole Wong. Hi, everybody. Okay, we're rereading that. Oh, that's amazing. This court specifically rejected the imposition of a reasonable diligence standard on trial defense counsel, stating, quote, "This court has never analyzed a Brady claim through the lens of reasonable diligence, and we decline to adopt that requirement now due to its lack of grounding in Brady or other Supreme Court precedents." Nailed it. Hello. Nailed that. Pick up the phone. If you didn't hear that, she just showed. I mean, if nothing else comes out of this, you guys, that right there says it all. We decline to adopt that requirement now. We decide not to follow the law. We abandon due process and human rights. Oh my God. Okay, let's keep going. In 2019, the court articulated that any diligence requirement on the defense contravenes Brady and Supreme Court precedents, but in addressing Mr. Avery's Brady claim on the suppression of the VLCD, both lower courts agreed that trial counsel failed to exercise diligence. The Court of Appeals imposed a burden on the defense to generate its own report and analysis of raw computer data. However, given Waskey, the pertinent consideration should be whether the prosecution had possession, not disclosed to the defense, the evidentiary value, not whether the defense could have sought it itself. See, Waskey, I'm going to say it wrong from here on. I can't help it. That's how it comes out. A rule thus declaring, prosecutor may hide, defense must seek, is not tenable in a system constitutionally bound to accord defense due process. The weakness of the Court of Appeals analysis is demonstrated on its exclusive reliance on a Southern District of New York case, ironically, United States versus McGinnis, is in opposite and not controlling or persuasive authority. The Court of Appeals relied upon McGinnis for the proposition that Brady does not apply to, quote, secondary complications or analysis of such. McGinnis has nothing to do with secondary complications, and pertains to the knowledge a defendant would have about whether he took bribes. This would be comparable to Mr. Avery claiming that knowledge that he has about whether or not he committed the murder of Halbach could ever be a Brady material. The defense was prevented from making any meaningful use of the raw data because of its untimely disclosure. See State versus Harry. The prosecutor misled trial counsel in 3 significant ways. Number 1, that all the disks it had were disclosed. Number 2, that the computer was Brendan's. And number 3, that the analysis of the data was of no evidentiary value. The prosecution lied about whose computer it was. Certainly affected trial counsel's decision not to evaluate it. When police or prosecutors conceal significant exculpatory or impeaching material in the state's possession, it is ordinarily incumbent on the state to set the record straight. The state finally did set the record straight 12 years later in 2018. It was not until then that Mr. Avery could have realized its evidentiary value. The lower court should be barred from imposing any type of reasonable diligence burden on defense counsel, especially in light of a prosecutor's dishonest conduct, aka known as CRATS, which is sweaty crack to me. Prosecutors' unwarranted concealment should attract no I got to see this again. Okay. Prosecutors' unwarranted concealment should attract no judicial approbation. I'm going to say that means, out of my, no skill at law, I'm going to say that prosecutors, okay, so their no need to concealment should attract, there should be no law banning us to know what they're concealing, is what I think that says. I didn't quite get that, so I wanted to really look at it. Okay, number 2. This court should address whether forensic findings contained on the CD that is not disclosed to defense counsel is evidence suppressed. This court, following Supreme Court jurisprudence, defines suppression as non-disclosure or withholding of evidence from the defense. Way scary. I can't say it the same way 3 times. Following Supreme Court reasoning, this court reiterated that, quote, the prudent prosecutor will resolve doubtful questions in favor of disclosure, finding that even a prosecutor's good faith is irrelevant to this inquiry. The issue is whether Veli's, quote, final investigative report, although in part based on raw data, disclosed to trial counsel constitutes evidence suppressed. It is undisputed that the Veli CD was withheld from all prior counsel until April 17, 2018. It was suppressed for 4,360 days after its creation. There is no possible way prior to April 17, 2018, current or prior counsel could have guessed Veli's specific search terms or the results which were on the CD. Without an evidentiary hearing, Mr. Avery was denied the opportunity to correct the circuit court's factual error that the CD and 7 CDs were identical. Although the Court of Appeals recognized that the CD contained different information than the 7C DVDs, it reached the same conclusion in an equally misguided way. It found that the Veli CD does not contain any additional information than what is on the 7 DVDs. But conversely, it deemed the material on the Veli CD was not evidence. The Veli CD is not suppressed evidence, but merely an investigative summary of evidence. Yeah. The Court of Appeals ignored Mr. Avery's allegation in his post-conviction motion and improperly weighed the evidence. It gave more weight to state forensic investigator Veli's affidavit than to Mr. Avery's allegations and supporting material, including the affidavit of Mr. Avery's expert who reviewed the Veli CD and the 7 DVDs and found the CD contained unique information. In determining the facts, the Court of Appeals improperly took on the role of the circuit court, effectively failing to address whether the circuit court erroneously denied Mr. Avery an evidentiary hearing because he pled sufficient facts in his post-conviction petition, which is the pertinent question. As with any other civil pleading, in assessing the legal sufficiency of the motion, the court must assume the facts alleged therein to be true. Even if the court is disinclined to believe evidence offered by the MOVA, the court must hold a hearing before making credible determinations. Allen, 2004. Love this. Only after a hearing is the court charged with determining the issues and making findings of facts and conclusions of the law. Wisconsin Statute 974.06. The Court of Appeals erred in rejecting Mr. Avery's argument that he should have had access to the information derived from Veli's, quote, unique word searches, pornographic images, quote, refined for relevancy, and the like because it incorrectly deemed the report as a, quote, secondary complication or cumulation and analysis of such. The Veli report is not a secondary I can't even say this word, you guys, today. Completation. I'm going to say completation and analysis. So let's reread this. The Court of Appeals erred in rejecting Mr. Avery's argument that he should have had access to the information derived from Bailey's unique word searches, pornographic images refined for relevancy, and the like because it incorrectly deemed the report as a secondary commutation and analysis of such. The Bailey report is not a secondary cumulation and analysis. It is a primary analysis of raw computer data and crime scene facts. I need a drink and a breath. Woo! She is schooling them. This is Law 101. What do you guys think? Oh my God, I love this. What a way to start our day. I love it. So we got 18 in the house. That's awesome. Awesome. Let's keep going. Actually, it shows we have 96, but I don't know which number's right, so whatever. I'm just so excited. Are you guys still with me? I mean, if this doesn't lay the law down like peanut butter on bread, what does? It is smooth as Skippy. This woman is brilliant. You know, I look up to people that can communicate in a way that comprehension is required. I just adore that. And Mrs. Zellner, yeah, hats off to you and all your crew. You know, this is really good. I mean, in layman's terms, this lays out like literally kindergarten, first day. Sit in your desk. Please keep your hands to yourself. Let's follow the rules. If you got to go to the bathroom, raise your hand. Number 1, you put up a 1. A number 2, number 2. So let's get done with the poo-poo and get on to really what counts here. Right? Okay, here we go. The Court of Appeals did not weigh the fact that the state misrepresented in writing to the defense that there was, quote, nothing much of evidentiary value anywhere within the data extracted from the computer. Importantly, it ignored that the state's forensic investigator generated a report of Bobby's and not Brendan's search history of terms such as bondage, gun, stab, handcuff, rav, throw, bullet, and fire. Sorry, I have to click off the screen to hit that, but I wanted to show. Nicole said she's kicking ass and taking names. If you say a swear word, YouTube grabs it. So I wanted to show y'all that. It unreasonably determined that the state's representative in its stipulation project was merely an, quote, off-the-cuff description of disclosed evidence. No reasonable trial counsel would consider that the state's written remarks merely casual. The state's misrepresentation was anything but, quote, off the cuff, since it was explicitly written in the prosecutor's prepared stipulation, a legal significant document. Mr. Avery's trial counsel provided an affidavit concerning the state's non-disclosure of the CD, which the Court of Appeals also failed to consider. Ignoring this affidavit, the Court of Appeals overlooked the state's misrepresentation of whose computer was analyzed. I have a super itch on my arm. Give me a minute. I feel like something bit my arm. Sorry. Only Bobby had access to the computer during the day on the weekend or weekdays when the violent pornography search was conducted. I'm going to cough. Sorry, we're going to start this paragraph over. Must be pretty important because I keep getting interrupted. Excuse me. Ignoring this affidavit, the Court of Appeals overlooked the state's misrepresentation of whose computer was analyzed. Only Bobby had access to the computer during the day on the weekdays when the violent pornography search was conducted and on the day of Halbach's murder. So the state's misrepresentations were material. The prosecution misled the defense into believing there was, in fact, nothing of evidentiary value to even seek. The lower court erroneously imposed an additional burden on defense counsel of investigating potential state misrepresentations. See Banks. Inmate failure to investigate the informant status result from prosecution's misrepresentation and omissions, and inmate was entitled to credit the prosecution's statements. Amen. Pass the butter. Oh, yeah. That nailed it. Nailed it. Right there. Perfect. Perfect. We're going to see it all the way to the bank. Damn. You can bank on that. Okay. I will never forget Bank now. Wow. She is kicking ass and taking names. She's like, listen, I'm done playing with the Play-Doh in the kindergarten room. So I'm going to school you people. This court should clarify for the lower courts that Brady encompasses the suppression of a forensic report just as much as any other form of evidence containing facts that are impeaching or exculpatory. Number 3. The Court of Appeals misapplied the law concerning the materiality and The Court of Appeals misapplied the law concerning the materiality and cumulative effect of the evidence. The Court of Appeals admitted that the I am not going to be able to do this. What is up with me? The Court of Appeals admitted that the Valley CD might become relevant to the showing Bobby Dassey's motive in a future Wisconsin Statute 974.06 motion. However, it failed to address the cumulative impact of the CD and the additional evidence undermining the state's case. There's a subnote worthy here. We're going to read it. The Court of Appeals found that newly discovered evidence of a phone showing Bobby committed perjury at trial was inadmissible hearsay. This conversation is an exception to hearsay. Without a true cumulative effect of analysis, a lower court should not be permitted to conclusively deem that the movement cannot demonstrate a reasonable probability of a different outcome. Strickland at 694. The court must consider the totality of the circumstance and thus may not merely review the effect of each in isolation. The Court of Appeals failed to consider the cumulative effect when it rejected all Mr. Avery's claims, namely his newly discovered evidence, ineffective assistance of counsel claims, and his 5 other Brady claims. By failing to consider the cumulative effect of the errors, the Court of Appeals erroneously applied a standard contrary to even Strickland requiring that the Valley CD itself would have acquitted Mr. Avery. This is contrary to a well-settled law. See Weary v. Kane. To prevail on his Brady claim, Weary need not show that he, quote, more likely than not, would have been acquitted had the new evidence been admitted. A petitioner shows cause when the reason for his failure to develop facts in state court proceedings was the state's suppression of relevant evidence. Coincident that the third Brady component, prejudice within the compass of the cause and prejudice requirement exists within the suppressed evidence, is material for the Brady purposes. Banks. Oh, I love Banks. Hey, Corey Williams. I really like this Banks. Whatever case this is, I feel like I should look it up and read into it. It really sets some laws straight. Knowing its theory was weak, the state relied on Bobby's testimony to establish that Halbach never left Avery's property on October 31st, 2005. Mr. Avery has shown that the suppressed evidence was favorable and impeaching, and has also shown cause because he has shown that the reason for his failure to develop facts in his state court proceedings was due to the state's suppression of the material evidence. Mr. Avery suffered prejudice because the material would have impeached the state's key witness, Bobby, would have revealed his motive, would have qualified him as a third-party Denny suspect. Woo-hoo-hoo-hoo. Yes. Hey, fair witness. Hey, she says, he says, hey, Ducky, they say. Okay, considering I'm so excited. That was so amazing. I got to reread that. Mr. Avery has shown that the suppressed evidence was favorable and impeaching, and has also shown cause because he has shown the reason for his failure to develop facts in his state court proceedings was due to the state's suppression of material evidence. Mr. Avery suffered prejudice because the material would have impeached the state's key witness, Bobby, who would have revealed his motive, and it would have qualified him as a third-party Denny suspect. Thank you, fair witness. Thank you. Considering the cumulative effect of the evidence in light of all the errors combined, there is a reasonable probability it would have undermined confidence in the verdict. I'm going to take a drink. The showing warrants an evidentiary hearing. Yes, it does. Hey, Sherry Lynn Pontello. She put me up a little ducky with a clap. I wish we had a Zellner icon. That would be awesome. We could throw Zellners up there. Somebody work on that. There's got to be a way to add your own little icons to YouTube. I know people know how to do that kind of stuff. Okay, number 3. Whether a state actor's destruction of contested evidence in violation of Wisconsin Statute 968.205 is sufficient evidence of bad faith to require a hearing on a defendant's Youngblood versus Arizona claim that the destruction of evidence violated his right to due process of law. Okay. Take a deep breath and let's roll. In 2011, the state released bone fragments discovered in the Manitowoc gravel pit, aka gravel pit, placed in evidence as part of the investigation of Halbach's murder to Halbach's family. It did so without giving any notice to Mr. Avery. The state removed evidence tags signaling the locations from which the bones were discovered and commingled the gravel pit bones with bones from 2 other areas, the Avery burn pit and the Dassey burn barrel. Shortly after post-conviction counsel moved to remand for additional scientific testing, it was discovered that the state, in 2011, returned bones to the Halbach family, effectively destroying them, without first giving notice to Mr. Avery's counsel. Mr. Avery then moved the Court of Appeals to stay his appeal and remand for the Circuit Court to consider his claim relating to destruction of evidence pursuant to Wisconsin State Law 968.205 and Youngblood versus Arizona. The Court of Appeals directed the Circuit Court to permit Mr. Avery to pursue a supplemental post-conviction motion and conduct necessary proceedings. The Circuit Court denied Mr. Avery's motion without a hearing. Excuse me. Sherry Lynn says the bone evidence should now be considered tainted, unreliable, and trash. Yep. Give her a bow. She is totally right. Yep. I mean, I feel like, okay, I have to stop for a minute. I have to do it. I have to bring something up here while I have the attention of those that are into this and only looking at law. All right. Call me whatever you would like. Maybe you want to think that I'm silly, I don't do this in a way that matters. But to me, this is my passion, this Avery case, as well as finding missing people. But if the state is claiming that this victim is female, but they do not claim the evidence in the gravel pit, then they have no ground to determine if this victim is a female, because the pelvic bones were only found in the evidence they are denying to be human in their method of handing it off to the whatever. Are you following me? Are you getting what I'm dropping here? You smell what I'm dropping? Okay, are you stepping in what I see? I don't know. I don't do those very good, those little puns. But you smell what I'm cooking up in the kitchen here? How do they even know it's a female unless they are? So the fact that they have qualified this as a victim that is a female, that fact alone, they claim every damn bone is human. And in this case, the state is. If they even claim this is a female, because they have nothing in their evidence found, not in the quarry, that tells us what the sex is of this victim. We have nothing to truly tell us that it's even truly human. I mean, you got 7 Loki. Okay, it walks upright. So I'm going to repeat this for all guilters, all prosecutors, sweaty crats, king crats. Yeah, get your finger out your butt, put it in your ear, wiggle it around, clean out that crap. Because this entire $36 million case is in the balance of this fact. So here's your blackout moment. If you, as the state of Wisconsin, have went in law and claimed that this is a female victim that you have put Stephen Avery behind bars for, a female victim that Brendan Dassey is in prison for, then you have no choice but to be held accountable for every bone in this case, because that female bone, the only bone, is the pelvic bone, the girdle. And that, my friend, or frenemy, whoever you are, was found in the gravel pit. Period. So you can't tell me this is even a female I'm looking for. And yeah, the Hawbucks did have a male. His bones were found the year before down at the bottom of a bridge. So you don't want us to test the one bone that tells us it's a female. You're just going to let us assume it. So you're going to change our damn perspective and make us, well, that bone's part of it. So there, what if that isn't part of it? What if that is just a random female bone? And the only bone you used up here was from some Hawbuck relative, male, female, don't damn matter. Because you're not going to let us test it all anyway. Maya, are you having... My pug's having an asthma attack. Just a minute. You okay? All right. Okay. Oh my God. Carol's here. Carol says, ew, just turned in and heard Sweaty Kratz and his nasty bumhole. Ew. Oh, Lord. I did tell him to get his finger out his bumhole. I told him to get it. Kratz, get your sweaty finger out of your sweaty butt crack and stick it in your finger and wiggle it around and pull that crap out and listen up. That's probably one of the worst things I've ever said on a live. Okay, I think you can call this intermission. Sorry for you folks that are like, all I came here is to read this. But I did. I wanted to make the point being all serious here, you guys. If the state has claimed that this is a female, then the state has claimed all bones, period. They need to be held accountable for the destruction of the evidence, and they need to really be held accountable for the fact that these individuals were of knowing. There was bad faith because the one that was of knowing was Norm Gone. He's the one that wrote the law. You know, he got the awards and the acclamates for, getting up there and being like, we need to hold all biological evidence and I want a law made and it's all because of me because I'm so smart. But yet then he turns around and he hands off the exact evidence. He has went into a meeting and said, yeah, you guys can test. He's already handed it off. Okay, you guys, let's roll. A, Wisconsin Statute 968.205, preservation of certain evidence. Hey, look at that. It was just like, what do you call that, segue? Okay. This is getting pretty long, so we're at 25 pages. I'm going to read a few more pages. We're going to cut off the live, and then I'm going to take about a half hour. We're going to come back on, and so if you do miss one, don't worry. I'm going to post these so that you can go back and watch each part, just so that they're not so terribly long. A Wisconsin Statute 968.205, Preservation of Certain Evidence. In 2001, Wisconsin recognized the importance of the preservation of certain evidence for purposes of post-conviction relief in enacting several evidence preservation statutes. See Wisconsin Statute 968.05. Now, you guys, who helped design this law? Norm Gahn, all right? He is officially related to that. How does he play in the Avery case? He gave away the bones. How does he play in this law? See that 968.25? He helped litigate that, okay? Notably, nowhere in Wisconsin Statute 968.205 did the Wisconsin legislature provide a remedy for its violation. And Article I, or 1, Section 9 of the Wisconsin Constitution requires statutes to provide a remedy for their violation. Wisconsin Constitute Article 1(9). As such, this court has been clear. Wisconsin's courts have the authority to fashion a remedy for remedialess statutes. So they're saying, basically, you guys, you set a law, but you didn't set a way to fix the law if it gets broken. Like, what's the answer? If you, okay, so you set the rule, don't eat 3 cookies in a row. Now, what happens if that does happen? If you eat 3 cookies in a row, what is the next path? Because that's what law is supposed to do. Point you in the direction of the path you take next. But it just stops. It's unfinished. It's half-ass. Oh, here we are back about ass. Norm, them bones be gone. Thank you, Stacy Seabrook, for coining that phrase. Okay. Notably, nowhere in Wisconsin Statute 968.205 did Wisconsin legislature provide a remedy for its violation. And Article I, Section 9 of the Wisconsin Constitution requires statutes to provide a remedy for their violation. Wisconsin Statute Article, well, I think it's I, 9. As such, this court has been clear. Wisconsin courts have the authority to fashion a remedy from remedyless statutes. I read that again because I feel like that's really important here. It's a part saying you have the authority to set a precedence, and the Avery case would again write a new law in the justice system. Right? Swinging those imbalanced scales of justice back into place, because justice is all about that Libra energy, keeping it imbalanced. What's the forensic archaeologist that identified the pelvic bones? I think that's Dr. Bennett. Fair Witness asked that. Sherry says, didn't they find bodies before the quarry in the past? Yes, they did find a body. It happened to be Carmen Botwell's aunt, Deb Suckawati. She was found. There's alleged reports, and then there's formal reports. I've heard horrific rumors of how she was found, allegedly through townsfolks. I tend to believe the town folks in that area more than I believe police reports. Call me crazy, whatever. I can't discuss how she was found on air because it would probably violate all of every single YouTube thing there was, but I will tell you it involved pool balls and very serious insertion and strange things. So let's get off that. The actual report said that she was untouched other than a blow to the back of the head, and was fully dressed and face down in the quarry. Yeah, Sherry's like, wait, what? You know what, Sherry? You just gave us the next blackout. Thank you, lovely. I might throw y'all a bonus blackout just because y'all's my babies. I love ya. I do. You guys keep me sane. Like, I never have to worry about you guys, like, not having Steven's back. You know, in a world of inconsistency, it don't matter what people do or say to piss you off in life. You've always got the justice system's back, right? You're always like, I'm going to set justice straight. And I love that. Sherry says that's too uncoincidental. I believe there are no coincidences in life. I really do. Let's see. Where are we, you guys? We've got to get this rolling. What are we doing here? I think we're on page 32. Let's call it good. I need to get some food. Sherry Lynn wants to know what year that is. Baby, I'm going to have to look this up. There's no way I'm going to remember that. I mean, most of the stuff comes in my head, but when it comes to Deb Sukkawati, I really want to read up a little bit. I know that I'm very dusty on that. I used to know it backward and forward. So if you guys want to look up Deb Sukkawati, and tonight, if I get time, it depends on how late I have to work. I'm putting in a lot of overtime because I need to get some stuff done on my car. It's like I can tell it's going to be needing it. So I'm like putting in double hours. So I think I'm up. I don't know. I've been working 12, 14-hour days this week. But the good news is it's all going to happen. I've already got it all set up. So things are working out in my favor. And there's nothing wrong with my car. It's just, you know, you can tell you're like, I have to get my brakes done. Winter's coming. I want to possibly put new tires on. You know, I want to make it secure for winter. So, and before I close off, I want to say a couple things from my heart. First of all, please keep your eyes open for Michael Vaughn, 5-year-old, blonde hair, blue eyes. He's from Idaho. He is missing. He was last seen with a Minecraft t-shirt in Fruitland, Idaho. And he is 5 years old and desperately needs our help. I have a lot of hope in this case. Intuitively, I feel like something is coming to light soon. Maybe it's my own personal hope. Also, Summer Wells. Her name is Summer Moon Utah Wells. She is also missing from Tennessee. And she is also 5 years old with blonde hair, blue eyes. And her disappearance was from June 15th. Now, Michael has not been seen since July 27th. So you guys remember the little girl, Jamie Kloss, here in Wisconsin. She had been missing 80-some days, was found safe and sound. So there is hope, and I ask all of you, please share this information. It's so vital that we get these kids out there. So it's going to be one of those things where you're going to have to share this channel with Avery and the missing kids, because I feel he would stand. I've never heard anything different. I feel he would support, and Brendan would support, this activity. It also brings in awareness from those that are true crime watchers and very active. Like I said, I feel like, you know, we're a journalist. We're a freelance journalist in a way, and we do get that face out there. We do get the information out there. So I will have links below. I have to edit them in because this is live, so it might be a day or two, but I always get caught up eventually and put the links down below if I can remember. I love you guys to the moon and back. I want to say thank you, a huge hug to all of you that show your love back at me by subscribing or sharing or liking or whatever you do. You're just fabulous. All right. I'll see you guys in a little bit. I know that was like a long exit, but I haven't got to like just be on live and talk to you guys in a while. So I'll see Dark Side of the Moon soon. And Sherry and Fair Witness and Nicole and Carol and I don't know, whoever else is here and whoever stayed with me. I will see you guys all very shortly. Let's see. It is about 11:30. We'll get back together. All right. Thank you guys. Love you to the moon and back. See you again soon.